Are you an employer, or are you an employee who works regularly on a Sunday and are expected to work on a Sunday? Then a recent High Court decision from Mr. Justice Binchy in October of 2019 will be of interest to you. And the reason is this was a High Court case which dealt with the question of a Sunday premium and how much should be paid for the Sunday premium, or whether the employer was obliged to identify how much was being paid for the Sunday premium. So it's an important case. It's an October of 2019 decision from Mr. Justice Binchy, and the background to the case is as follows. The employees brought a claim against Trinity Leisure Holdings, a hotel in Dublin, Trinity Leisure Holdings Limited, trading as Trinity City Hotel. The employees in question brought a claim to the WRC, notwithstanding the fact that they had a contract of employment that says that the hourly rate of pay includes your Sunday premium based on you getting every third Sunday off. That is, you work 2 Sundays out of 3. In other words, the contract of employment in an express provision made quite clear that the rate of pay that the employees were getting, 2 employees, was calculated to take into account the obligation to work 2 Sundays out of 3. That couldn't be plainer. However, the employees brought a claim to the WRC on the basis that from their contract of employment, the amount of the pay that they were getting, the Sunday premium pay, should be identifiable from the contract, and it wasn't, because the contract simply said this includes your Sunday premium. In other words, the rate of pay, we've taken into account the obligation to work on Sunday, and your rate of pay is whatever it was in the contract. The employees won the case at the WRC on the basis that the employer had failed to give any evidence or failed to identify what part or how much of the rate of pay was attributable or referable to working on Sunday. The case was then appealed by the employer to the Labour Court. Again, the Labour Court found in favour of the employees, and found in favour of the employees on the basis that the employer had failed to adduce evidence showing how they calculated the rate of pay and how or what was referable to Sunday pay, to the Sunday premium. So remember, and this is important, the Labour Court found that the employer's appeal had to fail because they had failed to put forward evidence that showed how much was referable to working on Sunday. The employer then appealed this to the Labour Court, or to the High Court rather, appealed from the Labour Court to the High Court, and the High Court actually found in favour of the employer, and the High Court found in favour of the employer on the basis that the contract of employment between the parties was clear. It couldn't be any clearer. There was plain language. There was an express provision that the rate of pay that the employees were getting was calculated in a way that took into account the obligation to work on Sunday. And the High Court held that this contract of employment was the evidence at the Labour Court, and there was no obligation on the employer, no further obligation on the employer to adduce evidence as to how much was referable to working on Sunday or anything of that nature. In other words, the High Court found that the employee really had the obligation to show that they were not getting the Sunday premium, if that was the argument. And the High Court found against the Labour Court and basically said that the Labour Court had arrived at a decision on a matter of law because it had decided that a clear statement in the contract of employment signed by both parties could not be relied upon and instead must be proven in a particular way. This was a mistake, and the Labour Court was not entitled to do this. So the Labour Court arrived at a decision on a matter of law, but the Labour Court cannot arrive at decisions on a matter of law. Only courts can do that. And the Labour Court are entitled to arrive at decisions or at on matters of fact but not law. And basically the Labour Court also fell into error in deciding that the Organisation of Working Time Act imposed an obligation on the employer to draw up a contract in a particular way, that is, to explain the breakdown of wages referable to working on Sunday, or to adduce evidence at a hearing of a complaint to prove a statement agreed to by an employee in the contract of employment. These were findings of law, not fact, and the Labour Court was not entitled to make such findings. This is a very important case, in my view, because it shifts the burden back to the employee in a situation, a case like this, where if the employee is claiming that I'm not getting my Sunday premium, I'm not getting paid in accordance with the contract, then the burden is really on the employee to adduce evidence to show that proposition and to prove it. It's not up to the employer in a situation where the employment contract between the parties, signed by both parties, states quite clearly that the rate of pay that you're getting takes into account your obligation to work on Sunday. Because there has been decided cases by the Labour Court in the past, about which I've written on my website, employmentrightsireland.com, where the Labour Court said it wasn't enough for the employer simply to give a contract with a provision in it saying that the rate of pay is calculated taking into account the obligation to work on Sunday. The Labour Court in the past has found that the employer must give evidence of the different, how much is referable to working on Sunday from the rate of pay and how much is, referable to working not on Sunday. And as I say, the Labour Court has found in a number of cases, and I've written about them myself and I've referred to them and link to them from my website, employmentrightsireland.com, and now the High Court has found that the Labour Court fell into error on that head and basically is not entitled to oblige the employer to put forward evidence when an express provision in the contract quite clearly states that the rate of pay takes into account the obligation to work on Sunday. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. On my YouTube channel, I deal with all aspects of Irish business and Irish law, and I try to explain it in plain language so that people can actually understand what's going on. Thanks for watching.